2017 CF 15684, State v. Nelson, back from our recess. Ms. Hicks, is the state ready to proceed?
Yes, Your Honor.
Mr. Lahr, defense?
Your Honor.
Mr. Nelson?
Yes, Your Honor.
All right, please bring in the jury. Ms. Hicks, does the state acknowledge the jury?
Yes, Your Honor.
Mr. Lahr, defense?
Yeah, Your Honor.
Mr. Nelson?
Yes, Your Honor.
Ms. Hicks?
Thank you. Good morning. I want to begin by addressing some of the issues that were brought up by defense counsel on his closing argument. So I'm going to begin by talking about some of the law. And I know my co-counsel touched on it, but I'm going to follow up on some of the points that were more specifically addressed by defense counsel. So I want to start where he did, with premeditation. Because as we've discussed, there are two different types of first-degree murder. There's premeditated murder, and there's felony murder. Now, what is important is one of the instructions that talks about murder. If you return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. Instead, what is required that all of you agree the state proved either first-degree premeditated murder or first-degree felony murder. This is coming directly from the jury instructions that the judge will read to you later. Of course, it is the state's contention that we have proven both first-degree premeditated murder and first-degree felony murder. So let's just talk about the issue of premeditation. Because of the elements of first-degree premeditated murder, the victim is dead, Jennifer Fulford. That is actually a fact that the defense has stipulated to, that the identity of the victim in this case is Jennifer Fulford. That her death was caused by the defendant, not an issue in this case. And so the third element is that at the time he caused her death, he had the premeditated intent to do so, meaning that when he was committing the act against her, his intent was that she die. Now, defense counsel talked a lot about how buying the items at the Walmart in no way suggests premeditation. Why does a homeless man need duct tape? Why does a homeless man need zip ties? I'll tell you what, I'll give him the knife. He's homeless. Maybe you want some protection on the street, I don't know. But what does he need zip ties and duct tape for? Now, defense counsel once talked to you about how he didn't have the premeditated intent to kill her because what he wanted was money. For purposes of what I'm talking about right now, I'll give him that. Maybe that's true. Maybe he really did just want money. But here's the problem with that argument. There is no set time for premeditation. Let me read to you exactly what it says. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. And here's the really important sentence. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. What that means is it is entirely irrelevant if he intended to kill her when he bought the murder supplies. It is entirely irrelevant if he intended to kill her when he knocked on the front door. It is entirely irrelevant that he intended to kill her when he put her in the back of the car, when he drove her down to the area where she was found. If you don't believe that that shows premeditation, that's okay. Of course, it is the state's contention that that is exactly what that shows. Buying those things, forming a plan, and carrying out your plan, a part of which requires you to have your victim in the back of her own car for probably about an hour, certainly shows premeditation. But here's where the premeditation does matter. When he's stabbing her. This is not one stab wound. This is 7 stab wounds. This is taking duct tape and wrapping it around and around and around and around her head so that she can't breathe. That takes time. At the time he is doing that, can there be any other intent other than he wanted her to be dead? It might have started out, make her stop screaming. That takes one little piece of duct tape, like that. You don't have to cover somebody's nose in order to get them to stop screaming. But when you wrap the duct tape around her head over and over again, you are intending to kill her. When you take a knife and you stab somebody, not once, not twice, not 3 times, not 4 times, not 5 times, not 6 times, 7 times, you want that person dead. That is premeditation. That is unquestionably premeditation. At the time he was committing those acts, he wanted her dead. So the state has proven premeditated murder to you. The state has likewise proven to you the crime of felony murder. What the crime of felony murder requires is that the defendant caused her death during the course of a felony. So while he was committing kidnapping, or while he was committing carjacking, or while he was committing robbery, she died. So obviously this requires us to prove to you that he committed either kidnapping, or carjacking, or robbery. Doesn't have to be all 3. So what defense counsel touched on, what he wants you to believe, is that the state has not proven to you all of the elements of these 3 felonies. They're not suggesting that he didn't commit crimes of theft and of taking her car and of kidnapping. What they are arguing to you is that the state hasn't proven the higher crimes of kidnapping and carjacking and robbery. And that is simply not supported by the evidence. The law talks about what in the course of the taking means. So the crimes of carjacking and robbery are very similar. They have very similar elements. That in the course of the taking, force, violence, assault, or putting in fear was used to accomplish the taking. And of course, with the carjacking, it's the car, and with the robbery, it's the money. So defense is arguing that the taking of the money, the taking of the car, they didn't occur, those were afterthoughts. They didn't occur in the course of putting her in fear. In the course of the taking means that the act occurred prior to, contemporaneous with, or subsequent to the taking of the property. Meaning whatever he did to her in order to accomplish his goal of getting her property, occurred at any of those times. So you have to remember what happened. There's a knock at the door. She answers the door. According to him, he had the knife and he forced his way in. That's when it all began. Now we are in the course of the taking, and there is force and violence used. He forced his way in. He had a knife threatening her. That's assault. A threat is assault in the state of Florida. He had a deadly weapon. How do you know that that's what happened? Well, look at the alarm records. He is in that house for 22 minutes. The door opens at 11:32. It's when it opens and closes. It opens again later, but then it closes for the final time at 11:54. 22 minutes. Think about what Jennifer Fulford might have been doing during those 22 minutes. He tried to suggest yesterday that he didn't tie her up. He didn't do anything to her when he first got in there. One of two things had to have happened. He either had to have tied her up, either with the duct tape or the zip ties, and left her downstairs while he went upstairs to get the comforter, or he had to have forced her to go with him upstairs to get the comforter. Because we know somebody went upstairs. We know that motion detector in that master bedroom upstairs, two-story house, was activated while he was in the house. So one of two things happened. She's either bound downstairs or she's forced to go upstairs with him. Because there is absolutely no chance, it makes no common sense, that a man would force his way into that house, threaten her, and then say, hey, could you wait here a second while I go upstairs and get something? And she just stood there. Yeah, go ahead, I'll wait here. That makes no sense. And that is not what happened. Therefore, one of those two things had to have happened. That's robbery. That's robbery. Because ultimately what he did, by holding her there, he got money from her. He was able to get her ATM card and get money from her in the course of the taking. He had used that force before he got the money from her. He was only able to get the ATM card, the PIN number, and the cash because he used the force. Robbery. Now think about the car for a second. Defense wants you to think that that was just an afterthought. Oh, well, there's your car. Let me just take that. He had her keys. It doesn't matter if her keys were in her purse or in her pocket or somewhere else in that house. He had to find them and get them. It makes no sense that, hey, can I borrow your car? Sure, here's the keys, while you have me duct taped and zip tied. Of course not. He held her, and while he had her, he had to find her keys. That is a carjacking. That is a carjacking. As soon as he had her keys, that is carjacking. Ultimately, he of course takes the car, but depriving her of her right to her vehicle, taking her car keys, is carjacking in the state of Florida. But he ultimately puts her in the back of her car. Now, as I've been describing all of these things, the entire time I've been describing a kidnapping. Again, defense counsel wants to go to that element of intent. And the state has to prove to you, just like we talked about with premeditated murder, that he had the intent to kill. We have to prove to you that at the time he forcibly takes her, that he had the intent to cause her bodily harm or terrorize her. Now, again, it's the intent can be inferred from the actions that happened. Think about how terrifying it could have been for her in the back of that car. Duct taped, zip tied, wrapped in a blanket. He had her secreted in the back of that car, hidden in the back of that car, and she was terrified. The kidnapping began with the knock on the door, and it ended with the knife to the heart. Bodily harm was certainly caused, unquestionably, and terror was caused. So you can infer from his actions that at the time he knocked on the door, at the time that he kidnapped her, this was not a simple false imprisonment. This was somebody who wanted to terrorize Jennifer Fulford. So when you are considering the crime of felony murder, consider the felonies first. If you find that one of any three of these felonies has been proven, whether it's kidnapping, carjacking, or robbery, if you find that at least one of them, of course the state submits that all three have been proven, but if you find that at least one of them has been proven, finding that the defendant committed first-degree felony murder is very easy, because the elements are she is dead, they stipulated to that. That he did it, he's admitted to that. And that it was in the course of a felony. So if you find the felony, you necessarily find felony murder. That is the law. That is the law, and it is unquestionable that the state has proven these crimes to you beyond and to the exclusion of any reasonable doubt. But I want to talk to you a little further about this case. On Wednesday, you heard the defendant's confession. You heard his confession back from November of 2017, when he was talking to Detective Farrar and Detective Wagner. And then you heard him again yesterday, when he again confessed to committing this crime. And when he was testifying yesterday, he said something about the confession from back in November. And he said, I was playing a game. He said, I said things that I was just playing a game with them. He said that he knew that they were not giving him what he wanted back in November. They weren't giving him what he wanted, so he wasn't going to give them what they wanted. He decided he was going to play a game with them. Ask yourselves if that makes sense. Ask yourself if it makes sense that if he wasn't getting what he wanted, why would he give them more than what they wanted? He kept talking. He kept giving them information. He kept giving them details that only he could have known. So if his goal was to mess with them, why would he keep giving them more information? Because that's not what he does when he's not getting his way. You saw for yourselves what he does when he doesn't get his way. Yesterday, when he was testifying during his direct examination, He answered those, 4 or 5 questions that were asked by his attorney. And then when my co-counsel got up, the initial questions were on the topic that he wanted to talk about, because all he wanted to talk about was his probation officer. And so when he was getting on his cross-examination, the initial questions were about what he wanted them to be about, and he was fine. But then something happened. He said, after she started asking him additional questions that, in his opinion, didn't involve the probation officer, he said, "Why are you asking me all of these questions? I only want to talk about Julio Dominguez. I'm not going to answer all of these questions." And the judge told him he had to answer the questions. Somebody who has authority over him told him he had to answer the questions, and he couldn't control the situation. He couldn't control the questions that were being asked, and he couldn't control what was happening. And when he can't control the situation, you saw what happens. He shut down. He started having selective memory loss. He wasn't giving additional information. I don't remember. I don't remember. I don't remember. Yes, you do. It's just not going the way you wanted it to go, so that's how you're reacting. So I submit to you, when he was being interviewed back in November of 2017, he was telling the truth, the whole truth, and nothing but the truth. One of the things that he said back in November of 2017 was, and I quote, "I just want my story told. I just want my story told." He said it over and over again. Detective, why are you telling me all this? Like, why now? Why so much detail? Why? I want my story told. Ladies and gentlemen of the jury, during the course of this trial, the state gave the defendant exactly what he wanted.
Objection, burden shifting.
I'll sustain the objection.
We told you his story. We told you what happened. But it's not really his story. It's Jennifer Fulford's story. It's the story of what happened to Jennifer Fulford on September 27th of 2017. The story began on September 16th of 2017, when the man who would ultimately cause her death went into a Walmart and bought the implementations of her death. The zip ties, the duct tape, and the knife. Jennifer's story continued on September 27th, when there was a knock at the door, and he forced his way in, bound her, tied her up. That's when it started to not go the way he wanted it to go. Whatever happened to just giving the guy what he wants and letting him leave? He didn't count on something. He didn't count on Jennifer Fulford being stronger than him. He didn't count on her not cooperating with him. And so he had to continue. Jennifer's story continued with him tying her up, getting the comforter, putting her in the back of her own car, and taking her to the ATM. The next chapter of Jennifer's story is driving from Winter Park, an affluent area that the defendant despised, clear across the county to the shadows of the happiest place on earth. It was not a coincidence that he picked that location. It would make news if a body was found in the shadows of the happiest place on earth. Her story continued when he opened the back of that car. "I'm not going to let this bitch testify against me," he said. "She wouldn't stop screaming, so I duct taped her whole fucking head," he said. He then takes her out into that field, and you heard what the last moments of Jennifer Fulford's life were like. He said, "I put one through her heart. I turned the knife, and she was still alive. And even though it sunk right in the middle of her chest, I knew that if I just moved it, she let out a gasp, and that was it." That is not fiction. That is not a TV show. That is not a movie. That is real life. That is what happened to Jennifer Fulford by him. You saw the next chapter of the story. You saw him go to the Publix. You saw him take his bus rides. You saw him go to the ATM again in Winter Park. You saw him go to the Amtrak station, buy the ticket, get off the train in Jacksonville, and 2 days later, use her ATM card again. But ladies and gentlemen, when you go back into the deliberation room, I invite you to watch one video. There is one video that I invite you to watch if you watch nothing else. And it is a 5-minute and 2-second video at a 7-Eleven in Winter Park. Because he left that train station and he went to that 7-Eleven and he bought a pizza. And you will see him in the Amtrak video eating that pizza. And when you watch the 7-Eleven video and you see him buying that pizza, think about what he said about that pizza. "I called it the blood pizza. I finally made someone pay for all the shit I've been through, and it would send a tremor through the community of Winter Park. I took my blood pizza because somebody died for me to get that fucking pizza. And so I'm carrying my pizza. Little do these bastards know what I had to do for this freaking pizza. And I walked back up to that gazebo and I ate that pizza. Every bite of it. And I enjoyed every damn bite of it. I really did. And I hope my only regret is that I hadn't killed 30 more sons of bitches like her, because I wish I had." Ladies and gentlemen of the jury, through the testimony of that witness stand and through the evidence that will go back into the deliberation room with you, the state of Florida has proven beyond any doubt each and every element of all of the crimes of which the defendant is accused. We have proven to you the beginning of the story. We have proven to you the middle of the story. Ladies and gentlemen, the story ends today. The story ends when you go back into that deliberation room and you find the defendant guilty of kidnapping, carjacking, robbery, and the first-degree murder of Jennifer Fulford. Jennifer's story ends with him being found guilty.